5 seconds to go. Start. It shows that by changing the insurance companies, the respondent was in the habit of making wrong claims. It is submitted that in view of the suppression, non-disclosure of hydrology data of the previous year, though it was available with the respondent, the appellant has rightly repudiated the claim of the complainant company. It is contended that the National Commission, without considering the matter as per the settled legal position by recording erroneous findings, allowed the claim made by the respondent. In support of his argument, the learned senior counsel has placed reliance on the judgment of this court in the case of Oriental Insurance Company versus Mahindra Construction. On the other hand, Shri Neeraj Malhotra, learned senior counsel appearing for the respondent, by taking us to the findings recorded by the National Commission and other material placed on record, had submitted that there was no suppression or fraud played by the respondent as pleaded, and the claim of the respondent was rightly allowed by the National Commission. The learned senior counsel has also submitted that in the absence of any errors in the order impugned, there are no grounds to interfere with the same. It is contended that the appellant is aware of the conditions of the insurance policy which the respondent has obtained for the previous year 2001-2 from Messrs. IFCO Tokyo, and as per the same terms and conditions, the subject policy was issued by the appellant. At no point of time the appellant asked for the hydrology data. It is submitted that without informing the respondent, the appellant has appointed Messrs. A.K. Gupta and Associates for carrying out a survey and called for report on the loss of power generation. The surveyor appointed by the insurance company had submitted a report which was not even furnished to the respondent, and based on such report, the claim made by the respondent was repudiated. It is submitted that having regard to the material produced before the National Commission, it has come to a definite finding that there was no suppression or no disclosure from the side of the respondent. As such, there was no reason or justification for repudiating the claim made by the respondent, and allowed the claim of rupees 4 crore 68 lakhs 33,840. On hearing the learned counsel on both sides and perusal of the material placed on record, we too are of the opinion that there was no suppression or non-disclosure by the respondent in suppressing any hydrology data of the previous year as pleaded by the appellant. The data of the years 1993 to 2002 could not be provided as the same was not available with the respondent, and it was also made known to the appellant. Stop.